Bar commissioners, you are invited to come up as well. Any other bar licensees who would like to participate, we would love for you to come up as well before Elizabeth takes the microphone. And just wanted to run down exactly how this press conference is going to go for those of you who just arrived. Elizabeth Wright is the Utah State Bar Executive Director. She will give opening remarks. Followed by her will be Bar President Kim Cordova. After Kim Cordova concludes her remarks, we will open it up for the press to give questions. We do have to vacate this room by 2:15. There are other people who need to come in. So the next 30 minutes, we will commence with this press conference. And again, anybody who would like to come up, please do.
Good afternoon, everyone. Thank you all for being here. As Jennifer explained, my name is Elizabeth Wright. I am the Executive Director of the Utah State Bar. I have been in that position. It will be 5 years in July. Prior to that, I was General Counsel for the bar, and I began working for the bar in 2011. So I have made a career out of lawyer regulation and representing the lawyers in the state of Utah, and I'm very proud of that role. I want to begin by explaining who the Utah State Bar is, or what the Utah State Bar is, and why we are speaking today. The Utah Constitution gives the Utah Supreme Court the exclusive authority to regulate the practice of law in Utah. By rule, the court has delegated to the bar all the administrative duties of regulating the practice of law. It includes admissions. We administer a bar exam twice a year, process applications. We license lawyers every year. They have to log on and take care of their license, verify that they've met all of their continuing legal education requirements. We keep a record for the public of all licensed lawyers. And we also, when necessary, we investigate and recommend discipline for lawyers who may have violated the rules that govern our practice. Importantly, the court's responsibilities in regulating the practice of law go beyond all of those administrative things. Lawyers are officers of the court, and we have many duties as part of that role, as does the court in running their branch of government. And to that end, they have also delegated to the bar the responsibility of supporting a fair and efficient administration of justice, of supporting the courts, of educating the public about the courts and their rights within those courts, and helping people access the courts. We are not a political organization, we are not a special interest group, and we are not an association. We are prohibited from endorsing political candidates or taking partisan positions. We do represent the lawyers and their obligations of supporting the oath they take and to uphold both the Utah Constitution and the U.S. Constitution, and in helping them protect the public, represent their clients, and assist the public in accessing the courts and understanding them. Because we represent the 11,000 plus lawyers in the state, we are governed by a board of bar commissioners. You see many of them here, and then other lawyers in the state. And those lawyers are elected. The board of bar commissioners are elected by the lawyers of the state. Every lawyer in the state elects a representative to the commission from their judicial district. Kim, who is the bar president, is elected by all the lawyers in the state. And our elected representatives work with the court on issues having to do with the regulation of the practice of law and our duties to represent our clients and our obligations to the Constitution. Importantly, the justice system does not belong to judges or lawyers or the legislature or the governor. It belongs to the people of Utah. Our role as lawyers, as officers of the court today, is to ensure that the reforms proposed to the court strengthen the system rather than undermine the public confidence in it. And when we see threats to the public confidence in the judicial system or changes that we as practitioners understand will not benefit the system or the public who is appearing in those courts, we speak out on those issues. And so that Kim is going to talk more about some of the positions we have taken. I have given you the framework about why we take those positions. And so I will now hand it over to Kim.
Thank you, Elizabeth. And I just want to start by saying that I am just so grateful that we've had such a great turnout and response to the efforts that the bar is making in response to some of the bills and some of the legislative processes that are occurring. First and foremost, we are lawyers first, but we're also citizens. And I think that as part of as part of being a citizen, it is our responsibility to really hold those that we put in positions of authority accountable and make sure that our voices are heard. And so, with that, I think that my position as bar president is that I ran. I ran and I had to put my hat in and put my name out, and I ran and I talked to a bunch of lawyers all across the state. And so I was voted into this position. And our commissioners are also voted in, as Elizabeth said, but during the legislative session, we have a government relations committee. And when you are a lawyer and you pay your licensing fees, there's other sections of the bar that you can opt in to be a part of. And that's usually your area of practice. And we have several sections. I think we have over 30 sections, and that whether that be family law, litigation, contract, juvenile, criminal, anything that you can think of in terms of area of practice, we have those sections so that lawyers can get support, so that they can make connections, and so that they can help give feedback in times like this when there are certain issues or legislation that's going to affect their area of practice. And so each of those committees, they elect a chair, which is their representative. And that representative, that chair, takes part in these government relation committee meetings where we go through bills, and we are very narrow on in terms of what we can take positions on. And so there are very few. But when we talk about the courts and access to justice and protecting lawyers and protecting the community, then the bar can take a position on a certain number of bills. And one of the bigger bills that came out this session was the expansion of the Supreme Court. And I know that it's already kind of gone through the entire system, but I think we just want to make it clear as to why the bar is taking a position on that. And so most people in our communities who have connections or have access or have touches with the justice system is usually going to be in the lower courts. It's going to be in justice court, it's going to be in district court, it's going to be in juvenile court. And to be fair, that's where the majority of our judges are throughout the state. And there's a different number of judges depending on the population and where their district is. Salt Lake County has the most amount of judges because it's the most populated, and then it kind of goes out from there. But Utah is growing, and it's growing all over. It's growing in the 5th district, it's growing in the 4th district, and so the response to the growth in population isn't necessarily to put more justices on the top where people have least access to. What we have supported and what we want to make clear is that the justice system and the judiciary and the courts desperately need resources, but they need them on the bottom end. They need judicial assistants. Judicial assistants are the people who calendar, who take notes, who get appointments, who basically run the courtroom. Some calendars in their district court on their criminal calendars, they're there for hours. They start at 8:30 in the morning. They go sometimes till 12:30 or 1. They have a small break, and then they pick right back up again, and sometimes they'll go after 5, several days a week. West Jordan, I believe, the West Jordan courthouse is going every day. There are shortages of bailiffs, judicial assistants that keep the courts running. And so what we're asking for is resources into the foundation of the justice system. Judges have, after they're in court all day hearing their calendars and the different hearings that they may be assigned to, they have to write. They have to write opinions. They have to write rulings. And they have virtually little help to do that. They have maybe one law clerk to 3 to 4 judges. And so if you can imagine 3 to 4 judges sharing maybe 1 to 2 law clerks who may not even be in the building and have not attended any of the hearings, who's doing everything virtually or in another part of the state, can be incredibly challenging. And so the priorities of what the courts were asking for was for the foundational resources that they need to keep the courts running. And as the population grows, more touches are going to be on the lower end. The need for juvenile court judges and district court judges are a great need. And so with the bill that passed, it did add in district court judges, which is a great need. But what we would like to hope is if there is funding that is available. I mean, the funding the amount of funding to support 2 Supreme Court justices, 2 appellate court justices, and 3 district court judges is going to be a lot of money, millions and millions of dollars, and ongoing, not just upfront, but there will be ongoing costs. In the higher courts, the support staff, the judicial assistants, and the law clerks are kind of built into what the ask is, but not for the lower courts. And so as those funding requests come in for appropriations for our courts, we are fully in support of and are asking for resources for the foundational parts of our courts in terms of judicial assistants and law clerks. And so one of the things that we were wanting to ask for is just a need, like a study for a need to see kind of where the resources need to go. We are told year after year that the budget is going to be tight, that they're cutting in education, they're cutting in other areas, but then to create a bill that's going to cost citizens millions and millions of dollars in maybe a way that isn't the most useful, is concerning. And the timing of this bill, I think is interesting considering it's immediately after, a number of controversial judicial decisions. And so when the legislature talks about structural change, and how judges need to be held accountable, I think many people are unaware of our judicial nominating process. And what that entails is that there's a separate nominating commission that is in each district of our state. So wherever a judge is appointed, there's a nominating commission. And the process can take anywhere from up to 9 months, realistically, of when they put their application in, which is a very extensive application, and about why they want to be judged, and they have to have references, for people who they work with, who opposing counsel, and then it goes to the nominating commission, who are 7 people from our community. Some of them are lawyers, some of them are not, and they are able to look at those applications. They go through all of them, and they then decide who they want to interview. And there's timelines in the rules about all of this, but it could take a lot of time because you're considering 7 people's different, calendars. And then they meet, and then they decide who they're going to interview, and they interview anywhere from 9 to 12, depending on the district and how many applicants they have, which could take all day, maybe sometimes 2 days. And then they ask them questions, and they vet them, right? They vet them. And then they choose 5 names to go to the governor. And then the governor staff vets them. And then the governor meets them. And then the governor makes a decision. And then that person, whoever is selected by the governor, goes to the Senate the Judiciary Confirmation Committee. And then they're interviewed. And then they are vetted. And then they're voted upon. And then that committee takes it to the full Senate. And then they vote on this person. And then they're appointed as a judge. And so it's a very rigorous and it's a very scrutinized process that takes many, many months, and is vetted by different committees and 2 different branches, right? The executive and the legislative. And that is for every sitting judge in the state of Utah right now that has gone through that process. And then there has been proposals to change that nominating process. And what is so amazing about that process is that it's merit-based, right? It doesn't matter kind of who you know or where you've been or what connections that you have. It's merit-based because we want the very best judges to be sitting on the bench. We want the best and the brightest to sit on the bench to hear our cases and to move our cases judiciously and efficiently through our justice system. And so we want to make sure that that process stays how it is because it's merit based and it goes through several levels of scrutiny before a person is nominated and then appointed on the bench. Judges also have, in terms of their accountability, something called the Judicial Performance Evaluation Committee, where after a certain amount of time that they are on the bench, people are asked questions of them and they're evaluated and they get reports based upon their the things that they do on the bench, their abilities, their demeanor, their procedural acumen, and those are also in code, but it's governed by the separate Judicial Performance Evaluation Committee. But those standards are created by the courts because it's the courts who oversee the lawyers. Similarly to how the courts oversee the bar, the lawyers, that we want to keep the separate branches of government to be who they need to be. We have 3 co-equal branches of government. And so when we talk a lot about these things, one of our concerns is the separation of powers. The regulation of the practice of law should be under the courts, right? The legislature or the executive shouldn't regulate the lawyers or the judiciary, as the judiciary and the executive shouldn't legislate the legislature or vice versa. And so understanding and really standing on and upholding the rule of law and the separation of powers is just foundational and part of the oath that we took in terms of upholding the Constitution. And so, so the main things are that we want to support the co-equal branches of government, that the court applies the law to the facts without regard to politics, pressure, or personal preference. And we want to maintain the integrity of that. And that's why we want to maintain the integrity of the process in which they are selected and the process in which they are retained. And so to say that there is no accountability is simply inaccurate, because if you look at kind of what the judges have to go through in terms of getting there, and then what happens after in terms of their feedback and their evaluations, and that they have to go on the ballot, that there certainly are times that that they get feedback and that people can hold them accountable for what they do. Accountability is not about controlling judges. It's about controlling ourselves and disagreeing better when the Constitution does its job. Thank you. We'll open it up to questions now.
So, you're an organization of lawyers. Is litigation on the table should some of these bills come to pass and be signed by the governor?
And so that's certainly something that we have talked about, and so it could be potentially be a possibility.
Do you have a position on the Constitution Court bill? I know that your organization has been working with the sponsor on this because he circled it on House floor and said he was working on the substitute.
I'm sorry, for which bill?
The Constitution Court bill by Representative McPherson.
Oh, yes. And so we do. And so whenever I think that there's a constitutional amendment, I think there should be a higher level of scrutiny.
This is the Constitutional Court, the special court.
Oh, the special court.
Oh,
I'm sorry. Maybe you can talk about that. Sorry.
Yeah.
Sorry. There's a lot of bills, I understand.
Yeah.
Sorry.
No, the bar is not at the table, but we have heard that there are discussions going on to work out some of the problematic parts of that bill. Again, we had a lot of objections. It was released on Tuesday and then it was before a committee on Wednesday. It's a very lengthy bill. Nobody had time to read it. If some of you may recall, some of the lawyers will, 2 years ago, Senator Brammer proposed creating the Chancery Business Court. It was a multi-year long process where all the stakeholders were brought to the table and all the kinks were worked out. I think, the bar isn't like, no, we don't want a constitutional court. It's an interesting idea, but let's think about it and do it slowly and iron out the kinks, bring all the stakeholders to the table. I think, having it sprung on us within 24 hours certainly put us at a disadvantage. And we're open to looking at it, but again, uh, I think a longer process with all the stakeholders at the table is the best way to proceed to add a whole new court. And then there's the budget issues. Again, it's really expensive. And, it goes back to Kim's statement about where should the resources go? Is that what we need right now to serve the citizens of Utah?
And one of you addressed Senator Wilson's argument for the expansion of the Supreme Court and the Court of Appeals not being a political maneuver, is that these judges would still have to go through the same process that Kim, you outlined for us, and the retention process as well. So he thinks that they would still have the same skill set and bring the same things to the table as those who are already on the bench. Do you buy that? And if not, why not?
So, I always think, right? I think that the more eyes, and I think this is one of the arguments that they made to kind of when they were pushing the bill forward, that more eyes on an issue is better. And we don't necessarily disagree with that. It's more of a resource issue. It's going to be more costly to staff and to expand the Supreme Court than it is for the lower courts. And the lower courts is where the need is. And part of what the bar does is it advocates in terms of our lawyers and for protecting the public and for access to justice issues. And it's just simply a fact that more people are going to have touches with the justice system in the lower courts than they are going to have in the Supreme Court. If we had an abundance of money and money wasn't an issue and funding, we could fund everything that we wanted, then it might be a different, we might be talking about different things, but for now, we have to talk realistically in terms of access to justice in the lower courts. All of us up here, we are working lawyers. We are working lawyers. I'm a criminal defense attorney. I go to court every day, right? And those issues on the lower end, on the foundational parts of the justice system are real. And that's where we would like to see the resources go.
In terms of resources, you mentioned you need the people who essentially run the courts. But could you give us an example of how those lack of resources are impacting the day-to-day or how our courts are functioning?
Sure. And so one of the examples that I gave of how long a criminal calendar may run, they may start at 8:30 or 9 and they could go maybe till 5 or 6 several times a day. And so what you have is you have individual citizens who are coming to court who may have to sit there for several hours before their case is called. And so if they're working, if they have transportation issues, if they have childcare issues, then and so realistically, that may be an impediment into how they are able to function and how they're able to respond. Jury trials. And so jury trials in some district court judges, they stack them 8 to 10 deep, right? And their priorities in terms of who gets to their cases to go first. And so if it's a misdemeanor case and they're in custody, then it gets top priority. And then it goes to felonies and whether they're in custody or out of custody and the severity of the level of offense. And so there was a murder trial that happened in Davis County, I believe last week, where the person had been in custody since 2024.
What are your thoughts on the collective impact of all the bills that have been filed so far? There's a lot. Like, if they were all to pass, what would be the impact totally, like, as a collective group of bills to the judiciary or to Utah's court system?
And so I think that's a really good question. And I think that when we look at individual bills that are coming through, it's like it's not impacted. What's the word where it's just like, like in math, how it just like power like doubles, right? Like squared roots.
Compounding effect.
Yeah, like a compounding effect, right? And one bill may undo one thing or like a 0.5 thing, and another bill may undo like another 0.5, and another bill may do like 0.2. Like for instance, like adding one thing here or taking away something here. And if you put them all together, then I think what it creates is is an attack on the rule of law and a separation of powers issue.
Can you talk at length about the retention and nomination process? There are several bills that are directly impacting that process as we know it now. We saw this start a year ago when we had some bills that were backed off later in the session. Just what do you make of the motivations behind this? That the legislature is still pursuing this? Is this purely because of these high-profile controversial decisions we've seen over the last 2 years, or is there a fundamental argument to make to change this process?
That's a tough question, and so I don't know if I have like a succinct answer to that. What I do know is that our judicial nominating process and selection of the judiciary is merit based, and it's one of the best models in the country. And so the merit based process of judicial selection, of wanting the very best and the most competent judges on the bench, is something that needs to be fought for, and it needs to be protected, right? It's the integrity of our justice system that our judicial nominating process stays as it is. And there has been infiltrations little by little. There was another bill a couple of years ago that changed it, and then there was another bill last year that changed it, and now there's another bill this year that's changed it. And so when you look at the compounding effect of that, then it's stripping away the integrity of how a judge is selected. And I don't know what the motivations of that are. I know that the timing of the expansion bill, and that can be, debated in terms of, I know that some people in the legislature said that they've been wanting to do this for several years, and that the decision making of, this past year has no impact on that. And I don't know. I mean, that's what they say. But what we do know is that if you cut away bit by bit into the Constitution and the rule of law, then not only does the judiciary suffer, but our society suffers, right? Because the protection of our citizens and the rule of law, I mean, that's who we are here to protect. We are here to protect the Constitution and our citizens. That's what lawyers do.
I know last year there were it was a similar feeling that there were a lot of bills sort of attacking the judiciary, but a lot of them fizzled out. The one that passed was the Supreme Court Chief Justice bill. Is your hope this year that many of these bills don't go anywhere and maybe only a couple do? Or how does this compare to last year? What are your hopes?
So I think that this year has been a lot more aggressive.
Yeah, they're more determined this year to make changes that they want to see.
We've seen less advance notice on some of the bills. Our hopes are always to be collaborative, and to be a contributing factor to making good law and good rules, to protect the Constitution and the separation of powers. And so those are our goals. Our hopes is that the legislature hears us, and that they continue or will continue to be collaborative in their efforts, and hear from the people that these laws will affect. And so, we are always trying to maintain good relationships with our legislature, and we want to continue to do that and to build relationships with them, and to maintain a very collaborative process. Elizabeth?
Speaking as a defense attorney, you can address the bill that Speaker Schultz has to add or to remove the defense bar from the Sentencing Commission, and talk about, he says that the Sentencing Commission is too soft, and he wants, can you talk a little bit from your perspective about how that would impact your clients in their cases?
Sure. I just think it's fundamentally unfair to discount one side of a conversation, right? In criminal cases, you have the defense and you have the prosecution. If you exclude 50% of the conversation, then what input do you have on good, experience-based, reasoned policy? And I think that if your voice is excluded when you're 50% of any type of relationship, I think that's a big concern. And I know that the bill went through committee last week, and it was, a lot of interesting things were said, about that. But it completely discounts the experience and the reasoning of half of what they're talking about. And I was executive director of CCJJ for about 3 years in the last term of Governor Herbert's administration. And so I'm very intimately aware of CCJJ and the Sentencing Commission. And one thing that was not brought up when we were talking about prosecutors and defense attorneys and law enforcement is that when these current sentencing guidelines were created, it was created in an evidence-based, research-based manner, with lots of stakeholders involved, including law enforcement, the prison, the Board of Pardons, all kinds of everybody who touches the criminal justice system, and the person who did that was a prosecutor and is now a sitting judge. And so, in the terms of the creation of those sentencing guidelines, it was created in a very thoughtful and evidence-based and collaborative manner.
We have time for one more question.
Chief Justice Durant, in his State of the Judiciary address, spoke about some of the natural tensions between the branches of government. I wonder, just from a very high level, if you could address how you see the judiciary's relationship with lawmakers and with the executive.
Right, it is an intentional and natural tension, right? We have three co-equal branches of government who are designed to check each other, right? We kicked out the king 250 years ago, and we didn't want one person saying what the rules are. So we have, I think, it was genius, the system that we've created where everybody is a stakeholder and comes in, and some people act as a check. And that's what the courts are essentially, right? They're the referees. We like the fact that they aren't partisan, they're not elected, they're not politically partisan, and they can make a call. And if they do check the executive or the legislative, the job of the executive and the legislature is to either take their lumps or to go back to the drawing board and try to create a system or rules that are constitutional or do abide by the law. And we've benefited as a democracy by that system for 250 years now, and I personally think it's genius, and that the tension is healthy and it's part of our system. But if it becomes, if there's retribution or other things involved, it's clearly the system is breaking. We need to respect when one branch acts and makes a check, or when another branch passes a law, and that's the sign of a healthy democracy.
Thank you. We'll conclude the press conference before